Dear learners, today in my lecture, I propose to discuss uh, a theory which is known as best interest or welfare theory in relation to the guardianship as well as custody of a minor child. In my earlier lecture, uh, it was pointed out by me that under Hindu law, Section 6 was challenged on the ground that it is violative of gender equality, Article 14, Article 15, and Article 21 of the Constitution, because Section 6 uh, provides that father is lawful guardian of the person as well as the property of a minor. And after him, a mother will be lawful guardian of the person as well as the property of a minor, provided that mother will be entitled to the custody of a child up to certain age, having regard to the uh, gender of the mind. And therefore, a challenge was made of this section on the ground that father is given preference over the mother with regard to the guardianship of the person as well as the property of a minor, which is based on the gender discrimination, which is not allowed under the scheme of the constitution. It is against the spirit of Article 14 and Article 15 of the constitution. And therefore, prayer before the court was that this section should be declared unconstitutional and deleted from the scheme of uh, Hindu Minority and Guardianship Act 19 of 56. The case was Geeta Hariharan versus State Bank of India and others. And matter was considered by the court, by the Supreme Court, and ultimately the Supreme Court held the provision of Section 6 as valid and constitutional, but gave a different mechanical interpretation to the word after used in Section 6 subclass 1 of the Hindu Minority and Guardianship Act 1956. And the court interpreted the word after, that word after should be construed not only after the death, but also it should be construed as in the absence of the father. So mother will be lawful guardian of the person as well as of the property of a minor, not only after the death, after the father, but even in the absence of the father, mother may be will be entitled to be the guardian of the person as well as the property of a minor under Hindu law. And here word after was interpreted that it means not only means after that death, but even it may mean in the absence. And therefore the court held that if the father in a given case is totally indifferent to the interests or welfare of the child, then he shall be presumed or deemed to be absent from the care of the child. And in that very situation, mother can assume the role of the guardian in place of the. So this type of, and in this way, attempt was made by the Honorable Supreme Court to bring the parents under the Hindu law to certain extent on the equal footing with regard to the guardianship of a minor. But under Muslim law, still no change has been effected either by the Islamic jurists with their mutual consensus, by ijma, or by any resolution, nor the Honorable Court has given any ruling that under Muslim law also mother under any circumstance can be guardian of the property of a minor, lawful guardian of the person as well as the property of a minor. Therefore, still under Muslim law, our rule is same what was propounded uh, so many years before. And still under Muslim law, or according to the Muslim law, father uh, is only, or males are only entitled to be the guardian of a minor, that is, and that those male relations are number one, father. And in the absence of the father or after father, lawful guardian of the person as well as the property of a minor will be his executor. Here, executor means the person who is appointed through a will to be the executor or caretaker of the person as well as the property of the minor. Now, the next to him is paternal grandfather, means if there is no father, and father also did not appoint anyone through a will as his executor, then in their absence, grandfather, if any, will be in the role of lawful guardian of the person as well as the property of a minor. In the absence of the paternal grandfather, his executor means if somebody has been appointed through a will as executor, then the executor of the grandfather will be in the role of the guardian of the person as well as the property of the minor. So this is the hierarchy of the relations under Muslim law, who will be entitled to be the lawful guardian of the person as well as the property of a minor. But it should also be clarified that a mother up to the certain age having regard to the sex of the ward or child or minor will be entitled to the hizanat or custody. Means father will be guardian, but mother will be entitled to the custody. And these are the two different concepts I have already explained. We need to reiterate. But guardianship is a wider right. It is a wider responsibility in respect of a minor child. But so far as the custody is concerned, hizanat is concerned, hizanat is a limited right which is available under the personal law to the mother who happens to be the female by gender. And therefore, only they are entitled to be the guardian of the person and property of a minor. But of late, uh, when there has been a question for decision before the court, any court of the country, and the question has come for decision as to who should be the guardian of the person as well as the property of a minor in a given circumstance, then the courts have evolved a theory, and that is known as the welfare of the child theory or best interest of the child theory. And normally now the courts In case of the dispute over the issue of the custody of a child between the father and mother, decision is taken, final call is taken by the court on the basis of the best interest under whose care the interest of the child will be protected in a best possible way, either father or mother. Therefore, having regard to this welfare principle, the decision is taken and welfare of the child is decided in a holistic way, taking into consideration various factors which may be responsible for the proper upbringing of the child. Therefore, the point of difference between the Guardian Wars Act and the Hindu Minority and Guardianship Act lies that on the lies in the emphasis placed on the welfare principle. Under the Guardian and Ward Act, paternal authority supersedes the welfare principle, while under Hindu majority and guardianship act, the welfare principle is of paramount consideration in determining the guardianship. Thus, for deciding the question of guardianship for Hindu children, their welfare is paramount interest which will override the paternal authority. But for non-Hindu children, the court's authority to intervene in furtherance of the welfare principle is subordinate to that of father as natural guardian. While welfare principle is used extensively by the appellate courts dealing with the custody issue, there is no evidence of the extent of its use by lower court based on a study of family court orders. Legal academician Asa Bajpayee notes. The best interest of the child may have been considered by the court, but there was no mention of this standard in orders. The courts did not give any information regarding the factors that may be considered are their reasons for awarding the custody. The order just mentioned to whom custody was awarded in a particular case. The problem with respect to the welfare principle is that despite its extensive invocation, the appellate judicial decisions do not illuminate the legal contents of this paper. Family law scholars note that while there are illustrations galore, no principled basis can be found in the manner in which the courts use the welfare of the child standard. A legal admission Archana Parasar analyzed the Supreme Court judgment from 1959 to 2000, used the best interest principle in custody dispute. Learned author Parasar concluded that in the absence of legislative guidance regarding what factors should be used to assess the best interest of minor, courts give varied interpretation based on their personal ideas about what is the best for the child and notion of the ideal pattern. For instance, there are contradictory judgments on whether the financial capacity of a parent is relevant factor in deciding the custody. Indeed, a large number of the judgments have established precedents in favor of the mother. But as Parasar rightly notes, these decisions are also based on the judge's perception of who is a good mother. Consequently, women who do not fit in such criteria would have difficulty claiming the custody of the children. The wide discretion available to the judges under the welfare principle also means that certain issues that should merit consideration are not treated seriously while determining the custody. Allegations of sexual abuse against the female by the children by the father, grandfathers, or other male relatives are brushed aside without any investigation if they appear improbable to the judges. A legal scholar and activist Flavia Enges notes in this regard that the court must exercise their power with great prudence and caution so that it does not result in the violation of the basic human rights of the children. The right to life, which includes the right to live uh, without fear and trauma, the detriments of the welfare standards should therefore be clearly laid down so as to prevent the judges from disregarding certain issues while determining the custody excess. Here she has reviewed the legal framework governing the guardianship and custody in India and has identified two areas that requires the legislative reform. First, the face of the child custody is changing. Numerous countries across the globe have adopted a preference for the shared parentage system over over system over the sole custody arrangements for the child dispute post divorce. This trend has arisen largely in a response to changing families' role. Caretakers taking on more child rearing responsibilities as well as rearing is preferably to sole custody arrangement. However, such preference for such custody are often biased with the best interest of the child standard. The best interest of the child is increasingly utilized as the tool to evaluate the child custody arrangements in many nations, particularly those who are signatories to the Convention on Rights of the Child. It requires the family courts to consider the well being of the child as paramount and delivered a path-breaking judgment on the gender equality. I ruled that even an unwed mother must be recognized as legal guardian of her child without forcing her to disclose the name of the child's biological father. The above judgment is a reflection of the dynamic thinking of the society experienced many upheavals a result of the switch the Supreme Court of India the Guardian Award Act 1819 in favor of the child at most welfare. Ladies and gentlemen, I have tried to discuss with the help of some of the cases, important cases decided by the high courts as well as the Supreme Court, that uh, in ordinary course of the circumstances, under the respective personal laws in a country like India, father is the first and best caretaker or guardian or custodian of the person of the minor. And Muslim law is more rigid on this point. Rigidity is to the extent that if there is father, no one can act on behalf of the minor under any circumstance as lawful guardian of the person as well as the property of the minor. However, in case of the dispute between the parties to the marriage, that is between the husband and wife, and pursuant to the dispute between the husband and wife, if there is a contest as to who is the best suited person in the given circumstance to take care of the child, the courts, it has been held that in ordinary course of the circumstances as well as under the customary law applicable to the parties concerned, father is the lawful guardian. And under Muslim law, mother under no circumstance becomes entitled to be the lawful guardian of the person or property of the minor once he has acquired the age of majority or has become the major or a fit person to make the final resolution. Now the time is changing. Dynamics of law is changing. Concept of laws are changing. And therefore, in the changed circumstances, now demand is coming up from the different forum that not only father but even a mother should also be the lawful guardian of the person and property of the husband. That he should become that, not only that in case of the dispute between the parents, not only father should be the lawful guardian of the person and property of the minor, but at the same time mother should also be made entitled to be the lawful guardian of the person as well as the property. Means a new concept has been coined, that is the concept of shared or joint guardianship. But at the same time, under the Guardian and Ward Act, pursuant to the section 25 of the Hindu Minority and Guardianship of 1969, now if the court is required to appoint someone as a guardian, then who can be appointed as a guardian? Now under what? Now the decision by the court will be based on the future welfare of the child, in whose care the child will be protected and in whose care the child will not be protected. So the criteria for deciding the guardianship in a given circumstance, in a given case, the standard criteria which has been accepted by the Supreme Court in its successive judgment is the criteria of welfare of the child or criteria of the best interest of the child. Means in whose care the child will be fully protected and will be in a comfortable position to grow in a natural way like a natural person. Court has to take a call thereon, and court will take the call thereon after considering the various attending facts and circumstances, including the moral character of the women. In this way, Supreme Court in a number of the cases has delivered the path-breaking judgments, and those judgments basically are worth reading for the readers, and points will be cleared that what is the requirement of the law at present so far as the interest of the child is concerned. And it is the duty of the court to protect the interests of the child, who is going to be at the mercy of either father. So, child should not be allowed to be at the mercy of the father or mother. Rather, the parents should be at the mercy of the child with whom the child would like to stay, either with the biological mother or with the biological father. These are the questions, some of the questions which are to be addressed. And to some extent they have been addressed, but it's still complete justice has not been done. So I hope that in the days to come, a mechanism will be developed wherein both the parents, that is father as well as mother, are the lawful guardian of the person as well as the property of the minor. Thank you very much, Shiv.